All right, sounds good. I am ready. Um, Hello, everyone. My name is Presenter in square brackets. I'm actually the first Australian person to have square brackets in their actual legal name. So if you'd like to name your children anything involving square brackets, feel free. My former name was Liam Inglis, and I am here today to present the How to Moot session. The purpose of today's session is really just to try to get you comfortable with the process of mooting and to share with you some hopefully helpful tips and tricks on what to do when you are mooting. The session is really aimed at people who have done maybe one moot before or who have never mooted before. And for most of you, you will probably be thinking about doing the senior moot this semester, or I understand the junior moot next semester. So that's really where this session is aimed. But hopefully, if you have more mooting experience, you'll still be able to get something out of the session. A little bit about me before we start. I'm Liam. I have competed in a number of moots, including the junior and the senior moot and 2 international moots. I've done a little bit of coaching and I've also done some judging as well. So I might be able to give you a bit of a perspective from both the competitor and the judge's side in the presentation today. All right, without further time wasting, let's start. So what is a moot? A moot is a competition that's really designed to kind of resemble appellate advocacy. So that's advocacy in kind of the High Court or Courts of Appeal. You will be given a set of facts that will describe kind of the background circumstances that have led up to 2 parties being in some kind of legal dispute. And it'll be your role as the advocate to take one of these sides and to prepare both written submissions and then subsequently some oral submissions, which you'll present in court, in the moot court before a judge. And the judge is normally an older student in the earlier rounds of an internal moot. But in the grand final round, there's often an actual judge of the Supreme Court, as well as probably a solicitor and the person who wrote the moot problem that your arguments will be based on. Unlike other competitions, you will get the same set of facts throughout all of the rounds. So mooting is just a bit of a process of getting a deeper understanding of both the facts and the relevant law and your own case as you go through each round. One thing that I forgot to mention in the time wasting portion of this presentation is if you have any questions throughout this session, feel free to post them in the chat or to just speak up over the Zoom, and then there'll be time at the end where you can ask any questions that you have about mooting or the competition in general, but I don't have the answers to the current senior moot problem, so I can't give you those. Moot teams are generally made up of 3 people. You've got your 2 speakers, they're the senior and the junior counsel. In actual court, of course, the senior counsel is normally a more experienced barrister and the junior counsel less so. But in internal moot competitions, it doesn't really matter. That's just the order of speaking. And equally, you'll have normally a solicitor, but it's totally fine to be in a team of 2 as well. So you'll just have the 2 speakers. Totally up to you and your own personal situation. So as for who is in the room, they're normally pretty closed door affairs in the preliminary rounds and in the quarter and semi-finals, but in the later rounds of competition, it's a good chance to invite your friends and your family along if you make it to the grand final. Okay, so why moot? There's a number of reasons that I think mooting is a really excellent bit of experience that you can get while you are at uni. First and foremost, it makes you better at both researching your legal issue and in writing, as well as in public speaking. And so each kind of stage of the moot, which we'll go through in a minute, develops a different kind of skill. And you'll find, I think, a lot in your subjects that the research that you'll do is very broad. It's to an essay question or to its kind of just understanding the legal principles. Whereas the research that you do for mooting is very practical. It's to kind of solve a problem within the context of your facts. And I think that kind of research is a very useful kind of research skill to develop. And similarly, when it comes to your writing skill, you'll be writing persuasive submissions that are aimed at convincing the judge or the court that your client has a winning legal case or defense. And so it's a different kind of very practical writing that you don't get as much exposure to through your normal subjects. Additionally, it's a great bit of experience for your CV. This depends a lot on the particular employer that you're seeking to apply to, but in general, and in my experience, a lot of employers look very favourably on particularly international meeting experience, and everyone starts in internal moots. So I think mooting is a great way to bolster your CV, and you never know, there's sometimes you'll be sitting in a job interview and the interviewer will have done the same moot that you've done. And so that's a good little talking point for you. And in addition to that, you meet a lot of people through mooting. You can imagine it's both your own team and the people that you compete against, as well as the judges that you get. And if you get more mooting experience, your coaches and your next set of teammates and etc. And that's kind of both friends and professional connections that you can keep through your career. And the last point here that has been a bit overlooked in recent years is that the UQLS sends teams around Australia and the law school sends teams around the world for mooting competitions. So traditionally, the Viz Moot, for example, is in Vienna. The Jessup Moot is in Washington, DC. And the IMLAM Moot, rest in peace. But if IMLAM is still running, then it changes location. It is in Singapore sometimes, and it was in Rotterdam a couple of years ago. And besides that, there's plenty of competitions all around Australia that run all the time. They've been online for a while, but I think they are just starting to become accessible again for travel. So that's something to look forward to. Okay, so how does the competition work? So this is a little bit, this has been a bit canvassed before, but every team begins with a set of facts. And these are the same facts for everybody. So it's not like in a negotiation, for example, where different teams will get hidden facts from each other. Everyone gets the same facts. And from there, you will research the law that underpins the dispute that your parties are in, and prepare written submissions that argue your client's case. In the senior moot and in the junior moot, there'll be 2 preliminary rounds, and you will be the applicant in one round and the respondent in another round. So generally moot problems are fairly balanced in terms of which one is easier to do. But in case it's not, you get a go at both, the winning and the losing side. And after those rounds, you'll be scored by your judges, and those scores will be tallied, and that determines the 8 teams that qualify to the quarterfinals. And then there's knockout rounds in the quarterfinals, the semi-finals, and the grand final. In addition to that, there's normally 1 judge in each preliminary round. So there'll just be 1 for those, but in the quarter and semi-finals and the grand final as well, you'll be before a panel of 3 judges. And so it can be interesting to kind of have to change up your advocacy a little bit when you get into those later rounds and of the formal judges. So where to start? So this, the rest of the presentation really is the tips and tricks section of it. We're going to go through each part of the moot from when the facts are first released up until when you are doing the actual oral rounds, and try and kind of guide you through the process and give you some tips for going through each part. So to begin, the best thing to do immediately is to read the facts, and that seems pretty obvious, but it's really vital that you have a strong understanding of the facts. You will often get questions in rounds that are like, you know, oh, what paragraph of the facts is that in? And does this happen in the problem? and it'll be your role to kind of explain those facts to the judge and to guide the judge through your own interpretation of those facts. And so it's important from the beginning to become familiar with them, but also you may know when you first read the facts whether you will be the applicant or the respondent in your first round. And it's important not to only think about the perspective of your own client, but also to think about what will my opponent be saying and what are the motives of my opponent's client as well. And that will hopefully give you a deeper understanding of both sides of the argument, just from a factual perspective. Now, in the problem, there will be generally a section right at the end, normally, that will set out the questions and the issues that are before the court. It might say something like, senior counsel for the applicant should argue these points, and junior counsel for the applicant should argue these points, and the respondent will argue the inverse. It's important that you pay pretty close attention to those grounds, to those sets of questions that are before the court, because you can't stray outside of those for the purposes of the moot. So, for example, on the left-hand side here, we've just got a list of, this is a paragraph from a previous year's junior moot problem, and that's the paragraph that sets out the relevant issues. And so you'll see, for example, the first one concerns a breach of clause 16 of this contract. So if you were to stand up and argue that clause 15 had been breached, that would be outside of the scope of the moot, and the judge might pull you up on that. So it's important that you pay close attention to the issues that are before the court that will be right at the bottom of the moot problem. And so that's what it means here when it says it should constrain your arguments. Then the next thing to look for when you are reading the facts is that either right at the end or throughout the moot problem, there might be reference to relevant case authorities and relevant legislation. And that's a really good point to start your research. These cases will generally be what the problem writer had in mind when they wrote the facts. And so you might end up finding some very similar fact patterns in these cases that have been cited. Now, these are a good place to start, and they'll probably give you a strong grounding in understanding the problem and the relevant law. In some cases, it will be useful to do more research. I would say if you want to do really well in the competition, you will need to do more research beyond just the cases that are cited in the problem, but you don't really need to be a team that competes well. So that issue is totally up to you, and we'll get more onto how much work is involved in mooting a little bit later, but for now, the kinds of cases that are cited in the problem are a good place to start. It's noted here that if you're unfamiliar with the law, probably a textbook is a really good place to commence your research. And I would say if you can and you have the time to read quite broadly through a textbook that's in your area. So for example, if you've got a problem on trust and you haven't done the law of trust, then it might be a good idea just to read the first chapter of a book on the law of trust so that you're not, you don't feel totally out of your depth when you're reading other cases in the area or when you're having a bit of a back and forth with the judge in the moot. Having said that, if you do have both a textbook authority and a case authority that stands for a particular proposition, in general, you should always cite the cases over the textbooks. Textbooks are a good place to kind of build your knowledge, but when it comes to written submissions, cases look nicer and they're more persuasive and authoritative. The other thing that's important right from the start is to just discuss things with your team. Obviously, in terms of dividing up research and work, it's good to talk with your team, but it's also a good idea just to step them through the kinds of things you've been researching and the kinds of things you're thinking about the problem. In general, as we'll discuss more, if your argument doesn't make kind of clear common sense to a person who doesn't have heaps of experience in the law, then it's probably not a great argument. And so discussing things with your team, especially your teammates who aren't you say have been researching another area of the problem, is a really great way to kind of strength test your own case. And that's kind of this next point as well. Really, the judge is often not as well versed in the law as you might be, depending on the judge and the moot. And so because of that, they're really going off their own kind of reading of the judging guide and of the problem and of your submissions, and kind of testing, does that make sense? Is that clear? Do I understand that? And do you have authority for the kind of points that you're making in the moot? And so really have a think when you first begin to develop your arguments. Like, would a person hearing this for the first time think, yep, that makes sense? Or does it kind of defy reason a little bit, even if you have authority for it? And so they're the kinds of steps that I would be taking when I first started the moot, beginning with what are the issues in the problem? Well, obviously I'd read the facts first, what are the facts? And what are the issues? Defined at the end of the problem. Where can I start my research? Textbooks and the cases cited in the problem. Chat with the team, and then is what I'm going to argue, common sense to a person hearing it for the first time. So that is the starting point. And then once you're through that, you'll probably be onto the stage where you are ready to bang out some written submissions. Now you'll see on the left-hand side here is kind of the template submissions. This is the kind of broad structure that you want to be going for when you are when you're writing your written submissions. You'll see at the top there the Roman numeral, like the text right at the top of the screen, Astra has not been falsely imprisoned. That text should come directly from the issues that are outlined at the end of the problem, these ones in paragraph 35 on the left here. So in effect, if I was doing this junior moot problem here, my submission Roman numeral 1 would be basically just the text of this paragraph 35A. So Mr. Myers' comments made on 14 June 2019 were a breach of clause 19 of his player contract, allowing the cattle gentleman to terminate the contract. And that would be the equivalent of your point 1 right at the beginning. So that's the other reason why your issues in dispute at the end of the problem are really important, because they should form the headings of your written submissions. And then after that, you will obviously break down your submissions into a series of sub-arguments that try to logically structure the argument in a way so that, again, the judge reading them for the first time will be able to go, that's clear, that makes sense, and I understand what they're trying to say. You want to keep in mind throughout that you're advocating for a client. When you are mooting, you're trying to convince the judge to decide in a particular way. And so your writing should be persuasive in nature. You don't want discursive passages about authority, for example. So if you've got a problem on tort and you go into the history of the law of tort, that's probably an interesting discussion, but it probably won't convince the judge that your client is right. So keep that in mind. You want every sentence in your submissions, ideally, to build that case that says my client on this legal issue is correct. And so you want to be as concise as you can. You want to cite your case authority where they're appropriate, and you want to stick very closely to the facts and the law that support your case. So for quite obviously, you want to have your team number. You want to say, counsel for the appellant or the respondent, and you want to say your names. Normally what you'll see right at the bottom of the set of submissions, and I'm not sure that these will be in the example, so this is probably important. The last kind of block of your submissions should say counsel for the, and whatever side you are, and that should be in bold. And then underneath that, you should have the name of the senior counsel, then on a new line, the name of the junior counsel, then on a new line, the name of your solicitor, if you have one. You can do it in other ways, but that's the most common way to do it in internal submissions. And that's normally how you get your, which side you're representing and your names into your written submissions. You'll often do when you say counsel for the, and then whatever side you are, you can go comma, team, and then your team number if you'd like as well. Otherwise, you'll have to put it in the footer or the header, which team you're in. So that's broadly written submissions. The key takeaway really when you're thinking about drafting your written submissions is think about, is every sentence of my submission actually building my case? Can anything be cut out? Is anything kind of superfluous background? Try not to go into too much long discussion of any case authorities. I would say in general, it's not necessary to describe the facts of any of your case authorities. So for example, if you're citing a case that stands for a particular legal proposition, you probably want to say, just say the legal proposition and then footnote the case. There's no need to say, in this case, these were the facts and this was the holding. In general, in some cases, particularly those cases that are cited in the body of the problem itself, it will be a good idea to go into some discussion of those cases, but it's only when the facts of the case that you're relying on are really relevant and you know that the other team is going to be making a big deal about that case as well. But otherwise, just stating propositions and then footnoting authorities is fine. Equally, I probably wouldn't do too much block quoting within the text of your written submissions. It takes probably too much room, and you want to be quite to the point. I think that there's some more tips on written submissions after this, but they're my general written submission tips, and I'm happy to, of course, take questions at the end or whenever you have them. Okay, so preparing for the oral rounds themselves. This is probably the part that people get most worried about when they are doing the competition. You bang out your written submissions and then you kind of don't know what to do to prepare for the oral round. It's often said to people, don't write a full script because, and the reason why that's often said is when you have a full script, the judge will ask you questions that might not relate to the point that you're actually in the middle of saying. They might relate to one that you've said before or one after. And you find that people, especially people who are new to mooting, do is they struggle to move from the point that they're on. And really the moot should be a kind of conversation between the judge and yourself in an ideal world. And so being bound to a particular point in your script is not a good thing. And so people are often told, don't write a full script. In my opinion, it's just a matter of preference. For some people, including myself, I find it very useful to write a full script. But then it's important once you enter the actual round, not to be too bound by your script. Equally, the more kind of common wisdom is to just do dot points. And so you'll have kind of a series of dot points that set out the broad structure of your submissions. And then as you get questions, you can talk around those dot points. That has the obvious advantage that you're less likely to become bound to the particular part of the script that you're in. But it also has the drawback that sometimes you're going to speak around your dot points and then you're going to do something really good, but you're not going to be able to then have it in writing so you can do it again. So broadly, a script can be an advantage or it can be a disadvantage, depending on your own personal preferences and style. I would say try doing both. If you're new to mooting, probably try a script first and see whether you do find that you struggle to answer questions because you've got your script. Or whether you find that you are able to move around the script without too much hassle. And equally, if you do start with dot points, consider whether you said a few things in the round that were really excellent or weren't very good, and whether or not you actually remember them well enough so that you can avoid them or incorporate them into your next round, depending on whether they were good or bad. So the ultimate takeaway there is probably don't stress too much about exactly the form that you have your speech in, but think about the advantages and disadvantages that both have, and whether or not your own speaking style will be conducive to one of those. The other thing that's important to think about before the round, which you often don't in your written submissions, is what kind of questions might a judge ask. You will probably find that as you go through your script or your dot points, you will see points where you think this is not like fully explained, or this gives rise to a question. And you want to be pretty quick with an answer to those kinds of questions if you have time to prepare them. It's a good idea if you have lots of time to go through and think about the kinds of questions that you're likely to be asked, and then kind of jot down just a brief answer to those questions so that you feel prepared when you get them. Of course, you can't prepare for every question because the judge can ask you about most things. And so you don't want to be taken by surprise when they ask you something that you haven't strictly prepared. That's when kind of thinking on your feet will come into it. But obviously, it's a good idea to think about the questions that you're most likely to be asked. Doing practice rounds is a really good way to get yourself prepared for the round for obvious reasons. What you might find is that once you're on your feet saying a submission before your teammates, there's parts in your script or in your argument that don't make a whole lot of sense, or that aren't particularly persuasive. And your teammates will probably be pretty quick to recognize those points. So it's a good idea to do probably as many practice rounds as you have time for, but most teams only have time for one or none. So it's fine if you don't get too much time for it. When you are actually getting ready for the round, kind of on the morning or the night before your round, there's just a list here of the kinds of things that you want to bring. Obviously, you want to bring the problem, and you want to bring a few copies. In an ideal world, you would have 3 or 4, depending on the number of people in your team. So your junior counsel and your senior counsel would have a copy of the problem that they just have on hand. Then you would have, your instructing solicitor with a copy, and if you feel it's necessary, the kind of loose copy that you have, so that you can pass it up to the person speaking if they've lost a part of, say, for example, the judge says, oh, where in the facts is that? And they can't find it in their copy of the facts. That is, your teammate can't find it in their copy. You might be able to hand them yours with the correct paragraph circled. And it would suck if they didn't give it back to you after you had given it to them, and then you're sitting there with no facts. So that's why a spare copy it never goes astray. You obviously want a copy of your own written submissions, because the judge might ask you questions about them, and also because if you get really lost, you can just pick them up and that will be a bit of a guiding point for you. Your opponent's written submissions are also a very good thing to bring in. The judge sometimes might ask you, oh, your opponents in their written submissions have said these things, how do you respond to that? So it's not a bad idea to have them on hand so that you can kind of go through those submissions with the judge when you get a question of that kind. Obviously, you want to bring in a copy of your own notes or your script, as well as those question answers you've jotted down or written out in full. Now, you want to bring in probably extracts of kind of the really key cases to your own arguments. It says here if they're not already in your script already. The reason for that is if you write out the full script, or even if you write out dot points, a good way to keep all of your notes together is to have the extracts of your key cases and your quotations of the facts kind of pieced in together in your script. So the way that I used to like to do it is I'd put everything into a binder, which we'll get to in a moment. And on the left-hand side of the binder page was my page of script. And then on the right-hand side of the binder page was were extracts from the key cases and the bits of the facts that I thought I would need in that bit of script. And so that's a good way to keep everything together. A similar way of doing it is you can have a paragraph of script, and then underneath that, in kind of a text box, you can have the relevant extracts from the facts in your cases. And if you're kind of a color-coded sort of person and you want to, put your facts in one color and your case extracts in another, that's kind of a good way to do that with the text boxes. But if you would prefer just to have all of your notes in one place and all of your facts and case extracts in another, then you probably do want to bring them to hand. And the reason for that broadly is that in your submissions, when you're speaking them to the judge, you might rely on a case authority, or the judge might say, do you have authority for that? And if you get pressed on it, it's really, it's very persuasive and it's very impressive if you are able to kind of just pull out that case and go, it says exactly this, and just quote from it. So for that reason, it's really good to have those cases on hand. Obviously, if you don't have time for it, that's fine. It's just one of those extra things you can do if you do have the time. Now, Ben, you might be able to correct me on this if I get this wrong. When I was doing junior or senior Moot, this is definitely a rule. I believe it still is. You can't cite cases that are, you can't rely on cases that are outside of your written submissions in oral rounds. So, for example, if you submit your written submissions and then before your round you do a bit more research and you find a case that is really helpful to your own argument, it's a good idea to bring a copy of that and then ask for leave. Thank you, Ben. So how that works is that your written submissions are in part for your opponents and for the judge to understand your case before you get there, before you get to the actual oral rounds. And so it's not really fair on either the judge or the other team for you to place a lot of emphasis on a case that is not in your written submissions. If you would like to rely on a case though, because you find it in that research between written submissions and the round, then the correct way to do that is to bring 3 copies of the case with you, the full case, not just the extract. And you want to ask the court for leave to rely on a case that's not in your written submissions. And I would say the best way to do that, if you want the exact words, is when you get to that relevant part, you would just say, Your Honour, might I request leave to rely on a case that is not within our written submissions? And the judge will always, or at least almost always, say, yep, that's definitely fine. And then what you want to do is hand a copy of the case that you're intending to rely on to your opponents. You want your instructing solicitor or your other counsel to then take a copy to the judge, and then you keep one for yourself. Often the judge will say that it's not necessary for you to give one to them, but it's important to have it on hand in case they do want it. That's just so that everyone is on the same page when you start to cite cases that are outside of your submissions. Now, to be totally clear, it's important that we say rely on the case in these circumstances, because there will be circumstances where the judge might ask you about an issue of law that's not really within the scope of your written submissions, but that you might want to have authority on. So for example, and this will almost never happen, so there's no reason to worry about it, but if you say asked about a point of, say, evidence, then obviously the cases related to evidence won't be in your written submissions. And if you throw away citation to an evidence case, the judge will be really impressed, but obviously there's no need to say, can I seek leave to rely on this case outside, but because the judge has kind of pulled you to those not strictly relevant cases. So the general rule is anytime you rely on a case outside of your written submissions, ask for leave and pass copies to everyone at the opposing counsel and to the judge, and obviously keep one for yourself. Now, you should also bring plenty of paper and bring pens for everybody. The judges will give you feedback at the end of the moot, and it's a good idea to write all of that down. That's one of the reasons that you want pen and paper. You will also want to take notes on the things that your opposing counsel have said, and you might just want to take notes for your benefit through the moot. So it's a good idea to have all of that. This is the most important comment that I'll make throughout the course of this How to Moot. Put all of your things in a binder. I think that I have said this in just about every junior moot round I've ever judged. I think that it should be on a sign outside the moot court. You must not enter here unless you have at least 2 binders. Like if people come in with a whole bunch of loose stacks of paper, you want to put all of that into a really professional looking binder so that you look like real proper lawyer people. I think that it makes you look so much more professional, and it makes it much easier for you to find your own materials. And that's why I get familiar with the order of it. There's nothing worse than seeing in the round, well, there's obviously worse things than this, but for present purposes, nothing worse. Then you ask a question, and as you're asking it, you see the person kind of lift up papers like this in front of their face and then flick through a whole bunch of them and then put them down and give a sigh like, I've just lost this key document that is supposed to be in my materials. So put it all into a binder and then make sure that you know, like, tab 2 in the binder are my facts, and tab 3 are my written submissions, and etc. So that's really key. If you're taking notes, I would cross everything that you've already written down and just write get binder and then take no more notes. And then obviously dress professionally. I have seen rounds where people have come, say, without, sorry, if you're a man, if you've come without a jacket, judges have told people off, or without a tie. I think in general, full suit if you're a man. I don't really understand women's fashion, so I don't know what you're supposed to wear, but make it professional, I suppose. Okay. Yes, okay, presenting. So when you begin the round, there'll be a portion of it that's not covered by this slide called the appearances. And in the appearances, what will happen is the judge will make sure everybody is ready and then say, I'll take appearances, please. And when that happens, the counsel for the applicant will stand up and present their appearances. They'll sit down and then the respondent will present their appearances. It's always the senior counsel for both sides that does appearances. And when you give appearances, what you will say is this: may it please the court, my name is Liam Inglis, and I appear with my junior counsel, say Ben Shank, for the applicant, and then their name, Mr. Smith or whatever. We are instructed by, and the name of your instructing solicitor, in this matter. I will be speaking for 20 minutes. My junior counsel will be speaking for 21 minutes, and we reserve 2 minutes for reply. So just to recap that, what you want to say is, may it please the court, then state your own name, state the name of your junior counsel, state the name of your solicitor, say who you represent, and then say how long you will both be speaking for. And if you reserve any reply, then say that as well. I believe that the same is said in the Raise the Bar guide, which gives you some tips on mooting as well. Otherwise, if you didn't get all of that down, feel free to ask at the end, because giving a strong appearance is a great way to start your moot, and you'll have to do it in every round, so it's a good thing to get down. Once you've gone through your appearances, it will be time. The judge will say, I'll now take submissions from the applicant team. That's when the senior counsel for the applicant will stand up and give their submissions. When you begin, and this will go for both the senior and the junior counsels of both sides, it's important that you start with a strong introduction. You want to put your own client's case in a way that makes them look good, but isn't really inflammatory. So what I mean by that is a bad introduction might go something like, we have 4 submissions. The first submission is, and then just state kind of the headings from your written submissions onto the first submission, and then just starting. It doesn't really put your client in a particularly positive light. You're not advocating enough if that's your introduction. Equally though, another bad introduction is something like, we're here today because this evil person on the other side, they make us sick, like that kind of thing is also, you're doing too much advocating, and your introduction is inflammatory. You want to try and strike a balance somewhere in between those two extremes. Think about what are the key themes in the problem. Has there been some injustice that has occurred that I can kind of allude to in my introduction? So how can I get the judge interested in a way that is positive to my own case? It really is the question. One thing to think about is, could I get asked a question about the things that I'm saying now? So for example, if you've got a contract case and you say something like, we're here because this contract has been breached, the judge might say to you, can you point me to where in the facts the contract has been breached? And if your answer to that question is long or complicated or breaks the flow of your own submissions, it might not be a good introduction. Giving a good introduction is very difficult, and it's something that will take you a number of rounds to perfect. So probably each time you go through a round, think about, did I get any questions in that introduction? Did the judge seem on board with it? Did they give me feedback at the end? And one thing that I think I would broadly recommend to everybody is ask the judge at the end of the moot, how was my introduction? That's a really good way to kind of feel out their stance on it. A lot of the time you'll just get, it was fine, like I didn't write anything down about it. That's the kind of thing I'd be saying if I got that question probably. That's just because the judge doesn't remember the introduction well enough. If that's the case, then try tinkering with it a bit before your next round. It might mean that it's just fine and you want it to be really good, obviously. On the other hand, if you're okay with it being fine, then probably don't stress too much, and the answer, I can't remember, your introduction is as good as any. Once you've gone through your introduction, you want to state broadly what the submissions you're going to give are. So you give your introduction that's positive but not inflammatory, and then you'll say, I will make two submissions. The first one is this, and that's when you kind of summarize your written submissions headings. The second one is this, my junior counsel will speak to the third and fourth issues, and there's probably no need to say anything more about that. And what those third and fourth issues are, that's their job. And then you will say, okay, now I'll move on to submission one. Don't say the word okay though, that wouldn't be sufficiently professional for the moot. And then you obviously just want to work logically through each of your submissions. It's a good idea to signpost your case. And what's meant by that is when you're moving between an argument, just say to the judge, I'll now move to this point, and that appears at, say, at paragraph 17 of our written submissions, or whatever it is in your written submissions. If the judge is clearly not reading your written submissions, you can probably stop doing that. But if they are reading the written submissions, then you'll really want to tell them, this is exactly where I am, so they can follow along with you. And if they're hearing it from you as you're saying it, and they're also reading it in your written submissions, you'll be a very persuasive advocate. Now, the question of dispensing with full case citations. This is something that only happens in internal moots, in my experience. It's a little bit silly. It doesn't happen in court either, but it's kind of an important formality. So there's a guide to this in the Raising the Bar guide as well, I believe. In effect, when you first cite a case as the senior counsel for the applicant, you'll want to read the case citation in full. And the way that you do that is, say, for example, you've got a case from 2020 and it's volume 200 of the Commonwealth Law Report, so the CLR, and it starts at page 1, just because that's an easy number to remember. You'll want to say that citation bit out loud in full. So the way that you would do that is, for example, that appears in the case of Smith and Smith, which was a 2020 case reported in volume 200 of the Commonwealth Law Reports, beginning at page and then the 1 or whatever page it begins on. And you'll want to do that just for the first case, and then you say to the judge, Your Honour, might I have leave to dispense with full case citations? And then you never have to do it again. It is a bit of a trend to say, might I and my junior counsel dispense with written submissions, and then kind of put it on the other team to do it as well. That's kind of a silly thing to me. I think the best way to do it is just say, you know, Your Honour, might both sides dispense with full case citations. You look nice, and it's kind of a waste of everyone's time anyway. Now, throughout the moot, the judge is likely to ask you questions, and this has been kind of discussed broadly throughout. You want to be ready for questions. Questions are good for your case because they're opportunities for you to explain it further and to allay any of the judge's concerns. We'll give some more guidance on how to answer a question in a minute, but for now, just keep in mind, if the judge starts asking a question, just stop straight away. Even if you're halfway through a sentence, like, because the question is good, you don't want to discourage the judge from asking them. And so the more inviting you are of the questions, both the friendlier you will appear as an advocate, the more convincing because you're open to that conversation, so you appear transparent, and also the judge will just like you more. It's kind of as simple as that sometimes. Now, you will of course have a maximum time to speak in. Try not to go over it. I've definitely stopped people before. I think most judges have. So probably time yourself. It's important to just have probably your phone and the stopwatch open there. Put it on Do Not Disturb, obviously. You don't want to be having to bang out a text message in the middle of your submissions. And equally, you want to go into the settings and make sure that your screen isn't going to go off. Because I've been in a few moots where people have had their screens turn off so they can't see the timer anymore. And then they're trying to maintain eye contact with the judge and type in their passcode at the same time. And it does look like they're banging out a text. So yeah, just change the settings. Now, when you are running out of time, if you think that you're not quite there yet, as in at the end of your submissions, you can ask for an extension of time. In general, it's better to just finish than to ask for an extension and summarize your arguments. The judge has just heard them, like there's no point to summarize them again. So for example, my advice would be, it's probably a bad idea to ask for an extension of time to conclude my arguments. Just finish them. There's no real need for conclusions. The right thing to do when asking for an extension is to seek the extension to answer a question. So for example, if you've got 20 minutes and you're at 19 minutes and you get a question, that's the perfect time. Your Honour, might I have an extension of 1 minute to answer this question? The judge will say yes, and then you can answer the question and hopefully do it in a way that is persuasive and ties up your argument well. That's not to say that you backtrack through everything that you've said, just say something that puts your case in a positive light. So that's extensions of time. And like it says here, it's much better to just calmly go through your last point and say, Your Honour, I'll rely on my written submissions for the remainder of my arguments, than to kind of rush through a whole bunch of content because the judge won't catch it anyway. And in their minds, they'll be thinking, they're hurrying because they're out of time. That's not what you're supposed to do. So I think we've talked a little bit about the tone of the moot. Formal conversation is kind of a difficult thing to understand, I think. I think really what it means is that you want to be giving when the judge is asking you a lot of questions, it will feel like formal conversation because you'll be in discussion with them. But if they're not asking a lot of questions, it's formal conversation in the sense that you're not giving a speech. You don't want to sound like a news presenter or like a politician doing the morning COVID update. You also don't want to look like the kind of beep boop moot robot that just, I've absorbed the script into my mind. I know the law. That's probably not ideal either. You want to look like the kind of friendly and open mooter that is happy to guide the judge throughout your own case so that they will understand it. And that's really the goal, making the judge understand what your case is. And so it's often described as formal conversation, I think, to get at that kind of idea. Okay, order of speaking. I believe that for the senior moot this semester, there's no cross appeal. So you'll just get the applicant, both of their speakers, senior, junior, and then the respondent, both of their speakers, senior, junior. Senior moot has a right of reply. So then the applicant will stand up at the end, and usually you reserve 2 minutes and you say your quick bit of reply, and then it's over. Cross appeals are more complicated, but not relevant here really. They're up in the slides. So no need to stress about that. Okay, tips and tricks time. Hopefully this is a helpful section of the Moot. One thing that I'll say before we do these is the kind of most obvious and most useless tip is know the law and know the facts. There's really no substitute to having a good working understanding of both of those things. But obviously all teams don't have infinite time to prepare the Moot. I was asked a couple of years ago when I was doing this session, how much work should we do when we're preparing the Moot? And I think that the answer really is it's up to you. The more work you put in, the more benefit you will get out, both in terms of your legal understanding and in terms of your success in the competition. Having said that, your goal probably shouldn't be to win the competition. It should just be to learn. And so you can learn as much as you would like. I think that the minimum work that you would want to do is to read the facts a few times. Between the members of your team that will be speaking, to read the cases that are cited in the problem, and probably to read a chapter of a textbook. I think that that's kind of minimum work. So if you're worried about the workload involved in mooting, then that's probably where you can aim. But obviously there is always scope to do more than that. And if you'd like to do more than that, you can read more cases and you can develop your arguments further and you can do more practices. But in general, I'd say that's the starting point. So the number one best tip is know the facts and know the law, but that is, of course, constrained by your own time. So some more helpful tips. Try to memorize your appearances and your introduction as well. Often in mooting, eye contact is noted as a really positive thing. You want to appear inviting and honest to the judge, and eye contact is a good way to do that. Try not to death stare them. That's scary, and I'll be put off by that. But generally speaking, eye contact is good. And if you're reading your appearances off a sheet, then you can't give eye contact. In addition to that, think about concessions. This is a really important thing in mooting because the problem will be finely balanced. So both sides will have reasonable arguments to make. And that means that some of your points might be losers. So when the judge starts to press you on one of those points that aren't particularly strong, it's really important to think, do I lose if I concede this? So for example, if you are claiming a breach of contract and the judge starts to press you, you obviously can't say, Your Honour, we accept the contract wasn't breached, because then you just lose. But equally, you have to think a little bit deeper about your concessions than just that baseline starting point. For example, if you say the contract has been breached and we rely on 2 facts to make out that breach, and you start going through the first fact and the judge says, I'm not really with you for these reasons, and you have a bit of back and forth and you go, okay, we concede that point. We also have this second fact. Now you can't concede that second point, or you do just lose again. So really think about, at every stage in my moot, what points can I concede and what can I not? And that's a really good thing to do before you go into the round. Because if you're having to do it on the fly, it's really easy to make a mistake. Okay, receiving your opponent's written submissions is an important part of the moot as well. What I often see, this is in myself and in my teammates and in teams that I've coached as well, I think everyone does this. You read your opponent's written submissions and you go, this is rubbish. How dare they say these things? And they're actually probably pretty reasonable submissions. So try and think really critically about the submissions that you've received and try and take their points at their highest. Like, if they made this point in the moot and they did it really convincingly, would we be in trouble? And how would I respond? And that's really what these next points go to. Think about what are the weaknesses in these submissions? Like, do I need to prepare responses to those weaknesses? And how can I attack them if I need to? So for example, obviously if they make a totally off-topic point, but it's also a really weak one, there's no point saying, now we'll address this off-topic point because we can win on it. That's just kind of point scoring and it doesn't make you appear persuasive. And then consider their stronger points too. So do I need to overcome their stronger points to win my case? Can I say that their stronger points are not really relevant? And if I do actually need to defeat these strong points that they have in their written submissions, how am I going to do that? And obviously, if you have time, try and have a look through some of the cases they cite. Again, that's not a must do, but if you have time, it's a good thing to do. And one thing to do before you go into the round is probably reread the facts. I think there's this weird phenomenon sometimes in moot teams where somehow collectively teams will just make up a fact. I've definitely done it in teams I've been in, and I've judged a lot of rounds where it's happened. And the team will confidently put forward a fact as existing, and you say that's not in the problem at all. It's only like 7 pages long. I don't know how it happens, but it definitely happens all the time. So reread the facts before you go into your round so that you know that you haven't made any of them up. Okay, answering questions. This is where moots are really won, in my opinion, in the way that people answer questions and respond to the bench. The best thing to do when you're asked a really complicated question is just take a minute. A pause always feels longer than it really is, and it's a great way to gather your thoughts. I think panic often sets in new mooters and experienced mooters as well when you get a question that you don't really know. So it's a good idea just to pause, let that little bit of panic subside, and to try and formulate a strong answer in your mind, or at least relax yourself enough so that you can trust that you'll reach a strong answer when you start talking. Taking a breath, I think, is a really good way to do that. There's nothing wrong with pausing, and in fact, if the judge asks you a question that they seem to think will stump you, and you don't pause, they'll be a bit taken aback. So definitely don't stress about pausing before you answer a question. Try to be clear and concise too. What you don't want is for people to commence a ramble. But it's definitely, sorry, I'll answer this question that's been put into chat. I know this is hard to answer, but how long is too long with pausing? That is hard to answer. I think that there's no set time. It depends on circumstances a lot. And one key thing that's important to keep in mind is it depends on your facial expression. A facial expression that appears to say, I'm considering this question, you can pause for 10 seconds and I don't think it would really matter that much. A facial expression that looks like, oh no, I'm really in it now. I can't believe they've asked me this. What am I going to do? A pause of 2 or 3 seconds can look embarrassing. I would say, so that's the first thing I'd say. Probably try and keep in mind that the way that you appear when you are taking your pause, because that will extend the length of time that you're able to pause and still look confident. The other thing is that even if you do pause for kind of too long, a good answer will recover it so that the judge forgets you have a pause. And equally, a bad answer that segues out of this kind of pit that you and the judge have dug each other into will also kind of negate the pause. So I wouldn't stress too much about the length of the pause. I would say you won't really know how long you have paused for anyway. But if you have gotten to the stage where you have to think, wow, this is a really long pause, it's probably too long. I know that's not a particularly helpful answer, but hopefully something to keep in mind. So yeah, trying to be as clear and concise as possible in question answering is also a really good thing to do. What you don't want is to ramble in your question answering. Thank you. I think that what you might get is a question that you're really happy to get because you have a lot of knowledge in that area, and then you just start this 3-minute long exposition into the background of the law of admiralty or whatever, and that's not really helpful. So try and be as clear and concise as you can in your question answering without being dismissive. So fully explain things, but don't ramble, and that's obviously again one of those how long is a piece of string kind of questions, but try to keep in mind. The other thing is most questions are yes or no questions, usually in disguise. So, for example, if a judge asks you kind of a difficult legal question, it's always best to start with yes or no, and then explain the reason or explain kind of the additions to that yes or no. So, for example, if the judge puts the question to you and you're like really that's a yes, but there's also these kind of things I need to add to qualify my yes. People often naturally put that like that, and they do the qualifications and they say, ultimately, yes, though. That seems like you're avoiding the question. You want to say right at the beginning, yes, however, and then do the explanation, because then the judge knows exactly where you're going. And that really goes for hypotheticals. A thing that people do a lot when you're new to mooting is you'll get a hypothetical from the judge. So that's, for example, if they say something like, I know our facts are like this, but what if I make this slight adjustment to the facts? Would your submission still be like this? Some ways that I've definitely had those questions answered are like, that doesn't matter because that's not our facts. But it kind of does matter because the judge is asking you, so they think it's relevant for some reason. So what you'll want to do is say, yes or no, our submission would or wouldn't still be that. However, or an explanation, so for example, yes, our submission would still be this, and that's because it gives a little bit of explanation, but regardless, in our case, and then you can move on from there. Always engage with the hypothetical, you'll appear dismissive if you don't. Another one, and we'll get, another one is just to say, if you really get jammed and you don't know an answer to a question, it's much better to say, I cannot assist the court than to just guess. That's especially true on authority. Most judges these days will bring a computer with them to their round. And so it's super quick for them to just Google the authority that you're trying to cite. I have definitely judged rounds where I have asked questions about authority and then Googled it, and the thing that the counsel has told me has been wrong. And that looks really bad, obviously. And in those cases, you'll probably lose points for it. Obviously, it's not the end of the world, and it definitely happens. But if you aren't sure about a question, it's much better to just say, I cannot assist the court than it is to guess. And for the reasons already mentioned, don't be afraid of questions. They're a great way to bolster your own case. Okay, there we go. So some quick helpful and unhelpful phrases. Helpful is in our submission and we submit. Never say it's our argument or it's our contention or anything like that. It's just submission in court. The next one is, if a judge is really asking you a lot of questions about a particular point and you've said your own submission a few times and you've tried to explain it, the judge just isn't on side, you can say, Your Honour, the highest I can put it is, and then say it. And that's similar with, we discussed before, concessions. If you've got one of those points that you simply cannot concede or you just lose, and the judge has put a proposition to you that really just defeats your case, and you can't say, Your Honour, that's not right, because what they've said is clearly right and it ruins your argument. But you know you can't concede because then you lose. The best thing to do is just say, Your Honour, the highest I can put it is, and then restate your own case. The judge will say, I get it, you've been jammed, but that's fine. That's what the problem demands. Or, you've got yourself into that situation and you found a way out of it. So that's a good thing. Try not to use it too often. Obviously, if, for example, the judge asks you one question about something and you go, the highest I can put it is this, they'll think, well, why is your case so weak? Why did you instantly have to defer to this strong phrase? So use it kind of sparingly, but it is a good tool to have. And again, if you don't know something, I cannot assist the court is a perfectly fine thing to say. When you are referring to your opposing counsel, it is, our learned friends said this. If you are a respondent team, it's a really good idea to quite frequently refer to the applicant's submissions. A learned friend said this, however, that misapprehends the law, or that fails to properly account for this fact. And that way you get a proper back and forth between the two teams and you are actually responsive. Another thing is, if you're really heavily relying on facts, I turn the court's attention to paragraph 10 of the facts, and then wait for the court to turn to that bit of the facts, and then you can make your case about that bit of fact. We've already described extensions of time, but I note that my time is about to elapse. Might I request this time to answer a question, almost never to conclude. Now, unhelpful things we would submit is like a bit of a pet peeve for some people. I said it all the time when I was mooting, and I was always told to stop, but I couldn't. We would submit is conditional, and it's not conditioned. You are making that submission. The other one that I think is unhelpful is with respect. I think it's something that people are often told to say, but they shouldn't. What I've been told very frequently, and what I've said as a judge, is some judges will get upset if you say with respect. I've never seen a judge get upset, but I have seen heaps of people say that judges could. I don't know why that's the case, but I would avoid saying it just because you're going to get that feedback if you say it. Another one is, we're getting to that. That'll appear later in my submissions, or I'll get to that point, or I've already said that point, or any kind of variation on that theme. If the judge is asking you a question, it's better just to move to that part of the case. Now, if, for example, you've got two submissions that you're going to make and the judge asks you a question about the second, it is helpful sometimes to say, broadly, our case is this. That will be further elaborated on in our second submission. Would Your Honour like me to turn there now? And generally the judge will say no. You also don't need to ask, would you like me to turn there now, if you don't want to. It's a way, like, it's a bit of a bluff, really. It hurts your case to have to turn there now if you want to structure it 1 and 2. And the judge will generally not ask you to move there. But in general, I would say what you want to do is avoid that kind of language altogether and just move to where the judge is trying to push you. So if you get asked a question that's about something later in your submissions, don't even say, broadly, our case is this, I can move there if you'd like. Just move there, and then structure your arguments about this new move that you've made. Either explain this point and go back to where you were, or just alter the order of your submissions if you can. So that's my helpful and unhelpful phrases. And this was the thank you page. Or did I skip something? Yes, I did skip things. Sorry about this. Okay, mooting workshop. Is there a mooting workshop that's running, Ben? If there is, it's a good chance to sign up and get a bit of practice before you head into the round. And it is running, excellent. It's kind of like a little mock moot that you can do just with your team and the judge, or with 2 teams and the judge. And it's just a way to get some feedback before you go into the actual round and get scored. The judges won't give you feedback on the actual legal points unless they're just totally crazy. Even then, maybe they're not supposed to, I'm not really sure. That's not a rule I've ever really followed. But in general, they'll give you points about the way that you're presenting and your style. That will be really useful in the actual rounds. You'll get more information about that, I assume, from the UQLS at some point. And then, where do I get more information? The UQLS competition rules, definitely read the rules. The Raise the Bar book is really good. It's got a bunch of tips like dispensing with case citations and doing appearances if you want those procedural things. There's a lot of kind of moot recordings on YouTube that you can watch. There's an Ames Court moot where a lady passes out during her submissions. That's really funny. Otherwise, there's a couple of segments of Jessup moots or Viz moots. That's VIS that you can look up, and they're really helpful because you'll see what really good mooters are like, and you can try and emulate them depending on your own style. And then obviously the UQLS competitions group posts about competitions because it's the competitions group, so that's a good thing to join. And if you have questions, I'm sure you can ask the internal competitions team, which is Ben and some other people, I assume. Okay, that is the end of the presentation. Please ask questions if you have them. I will be here. Okay, so this question, thank you very much, is what speech pace would be expected considering it is formal conversation? Would it be a bit slow? Yes, I think is the answer. The speech that you want to speak at broadly depends upon the point that you're making in a lot of ways. I would slow down during an introduction, have a lot of pauses in this kind of style. It will help the judge fully comprehend the introduction that you're trying to make. But obviously, if you're just explaining a kind of legal proposition that everybody has heard before, you can speak in this kind of faster pace. People often speak too quickly in moots. I think that's the key thing to keep in mind. When you get up to speak, the panic kind of sets in a little bit, not panic, that's the wrong word, I think, kind of the nerves, and you speak too quickly. I think the pace is definitely a little bit slower than you would be speaking in normal conversation. Keep in mind that the judge is hearing these things for the first time, and it's a lot to take in a complex legal proposition when it's spoken. So I would say definitely a little bit slower than normal conversation. And it's something that you will likely hear about when you get your feedback from the judge at the end of your round. So if you do get the feedback during your workshop or after your first round, you're too fast, then it's a really good idea just to slow down a little bit. Obviously, it's kind of a fine balance, but the kind of range of acceptable speaking speeds is pretty wide. So speak where you're comfortable, but keep in mind nerves will make you faster. So yes, hopefully that's helpful on speaking speed. But if anyone else has questions, please feel free to put them into the chat or to just use the Zoom. Otherwise, yes, hopefully this was a helpful presentation on how to Moot. Of course, if you have more questions, you can, I guess, email Ben. If you see me around, you can ask me. Always happy to help. And otherwise, good luck everyone in the competition or competitions. I hope you get a lot out of the experience. I think that mooting can be very valuable for you and your career. Okay,